Hello, this is Subodh sir. So today in this lecture we will be discussing what kind of questions are generally asked in the interview for judicial exam. Basically, as you all know, in all the state, judicial exam consists of 3 stages. We have PT exam, and those people who qualify in PT exam, that is followed by written exam, and at last we have interview and all. So when you go to face the interview, it is basically for 15, 20 minutes, 25 minutes, something like that. At max it can be 30 minutes. But then in those 20, 25, 30 minutes, they ask questions from almost all the laws. So before you actually appear for this judicial interview, you must master CPC, CRPC, evidence, IPC, and you must master all the acts as far as possible before you actually appear for interview. In interview, if you get very good marks, you can actually secure very good rank in the merit list, and that will actually ensure your success in the judicial exam. So today in this lecture we'll cover certain questions which are frequently asked in interview of judicial exams of various states. So when you go to face, I'm again repeating this, please master all the procedural laws, because many questions are asked from procedural laws. Questions like, what do you mean by cognizable offense? What do you mean by non-cognizable offense? When charges can be altered in trial and things like that, when a person can be made accused under section 319 of CRPC, what do you mean by arrest by the police without warrant? Can a private person arrest a person? What is the power of session judge, additional session judge? What is the power of high court and things like that? And they also ask questions based on who can appoint this public prosecutor, who can appoint additional public prosecutor, who can appoint session judges and things like that. So these are some of the technical questions that we'll cover. So to begin with, today in this lecture we'll cover few questions which are very important from examination point of view, especially in judicial interview exam. So we'll take a few questions and we'll try to discuss in detail that if those questions which are basically frequently asked in the interview, that if those questions are put up to you, what should be your appropriate answer in order to fetch maximum marks in the interview. So we'll pick up few questions and we'll try to discuss these questions in detail. Now let's see these questions. Question number 1. What is the maximum sentence that can be passed by a session judge? This is the first question. So if you see powers of courts in India, Supreme Court, any sentence authorized by law, High Court, any sentence authorized by law. When it comes to session judge can also impose any sentence which is authorized by law, but keep one thing in mind, session judge can also pass death penalty, but any death sentence passed by session judge is subject to confirmation by the High Court. And we have the relevant provisions in section 366 onwards with regards to what we call confirmation of death sentence and all. The matter will be sent to the High Court for confirmation. Once death sentence is sent to the High Court, it can take additional evidence or it can order further inquiry and things like that. Then after that it is confirmed, and you must know that death sentence must be signed by at least 2 judges of the High Court. So when a question comes, what kind of sentence can be passed by session judge, you must answer the question, any sentence authorized by law including death sentence, but death sentence is subject to confirmation of the High Court. This is the most appropriate answer for this question. What kind of sentence can be imposed by a session judge? And when you talk of additional session judge, he can also impose all the sentences which can be imposed by a session judge, and again it is the same thing, subject to confirmation by the High Court. When it comes to assistant session judge, he can impose a sentence from above 7 years and up to 10 years. So if you get a question, what kind of sentence can be imposed by session judge, answer should be any sentence authorized by law, but death sentence imposed by session judge is subject to confirmation by the High Court. This is the most appropriate answer for this question. Now let's take question number 2. What is the maximum sentence that can be imposed by Chief Judicial Magistrate? Now Chief Judicial Magistrate can impose sentence up to 7 years. And this Chief Judicial Magistrate, we also have additional Chief Judicial Magistrate and things like that. So if you get a question, up to what extent sentence can be imposed by Chief Judicial Magistrate, answer is up to 7 years. These are the simple technical questions which are asked in the exam, and the students, although they know many things, many case laws, they can cite so many case laws, they can speak at length, so many sections and things like that. But when these simple questions are asked, it is seen that they actually sometimes they land up answering in a wrong way, which creates very bad impression. So you must know what kind of sentence can be imposed, but by what kind of judges and things like that. Now question number 3, what do you understand by non-cognizable offense? Well, when you talk of offenses, it is of two types, cognizable and non-cognizable. In case of cognizable offense, a police can arrest a person without warrant, and in case of non-cognizable offense, police officer cannot arrest a person without warrant. In case of non-cognizable offense, unless there is warrant from the magistrate, a person cannot be arrested. And again, another difference between cognizable and non-cognizable offense is that in case of cognizable offense, police can immediately start investigation. But when it comes to non-cognizable offense, unless there is direction from the magistrate, no investigation can be started by the police officer. So this is the difference between cognizable offense and non-cognizable offense. So when you answer in this one, it will suffice your answer, and that will fetch maximum marks in the interview. Now next question, what do you mean by warrant case? Well, cases are of two types, warrant case and summon case. Warrant case is a case in which sentence of death penalty, life imprisonment or imprisonment above 2 years can be imposed. So if you get a question, what do you mean by warrant case? You will say warrant case is a case where punishment can be imposed, and that punishment can be death penalty, life imprisonment or above 2 years. And when you talk of summon case is a case in which punishment is less than 2 years. So this is the material difference between summon case and warrant case. Now another question which is very interesting is that, though sometimes we forget to answer this question in the right way, the question is, who can appoint a judge to preside over court of session? Now at district level, you have lots of courts. You have this session court, additional session court, assistant session court, CGM, judicial magistrate first class, second class and things like that. So if you get a question, who can appoint judges of session court? The simple answer is, judges of session court are appointed by the concerned state high court. So if you get a question, who can appoint judges of session court? The answer is, concerned high court can appoint judges of session court at the district level. Now next question is that, who can appoint a public prosecutor? Now you have in section 24 of CRPC, a person can be appointed as public prosecutor who has practiced for 7 years, and a special public prosecutor can be appointed if he has practiced for 10 years. Now public prosecutor in the states, they are appointed by state government. Central government can also appoint public prosecutor to conduct special cases and things like that. So basically public prosecutors, they are appointed by state government, and central government can also appoint if they wish those public prosecutors to conduct some special cases and things like that. Now a question arises, generally we have seen and we have heard also that police officer can arrest a person in a cognizable offense. Now a question arises, whether private person can arrest a person? Answer is yes. Under section 43 of CRPC, even a private person can arrest any other person, but there are two conditions which must be fulfilled before that private person can exercise the right to arrest any person. Condition number 1, that person must have committed non-bailable offense, and he must have committed a cognizable offense. If these two conditions are fulfilled, then in that case, that private person can exercise the power which has been conferred on him under section 43 of CRPC. He can arrest a private person. Absolutely no doubt in this regard. Now next question. So we will be discussing very important questions which are generally asked from CRPC, and in series we will be discussing CPC, we will be discussing IPC, we will be discussing law of evidence and things like that. Now next question, which are very important from CRPC point of view. How long does an order pass under section 144 remains in force? Now when an order is passed under section 144, it initially remains in force for 2 months. However, it can be extended up to 6 months. So if you get a question, for how many months that order initially remains in force? Answer is 2 months, and at max it can remain in force for 6 months. Now next question. Who can investigate a cognizable offense? Now cognizable offense can be investigated by officer in charge of a police station. Question number 1. In a cognizable offense, should FIR be lodged for starting investigation of the case? Answer is no. Even without registration of FIR, investigation can be started by the police, and as far as lodging of FIR is concerned, that can be done little later also. So if police gets information from some source that a murder has taken place, a cognizable offence has taken place, immediately the police can rush on the spot, and without wasting any time, the police officer can start investigation as far as cognizable offence is concerned. Now, registration of FIR is not a sine qua non for starting investigation in what we call cognizable offence. Now, who can record confession of an accused under section 164 of CRPC? Now, when you talk of recording of confession, it can be done only before the magistrate. And when you talk of magistrate, judicial magistrate or metropolitan magistrate. Question number 1. While recording confession under section 164, should that confession be recorded by that magistrate within whose jurisdiction the offence has taken place? Answer is no. Under section 164, confession can be recorded by any magistrate of any court. Of course, after recording the confession, it will be sent to that court for which that confession is required for trial and things like that. But it has to be recorded by that magistrate only within whose jurisdiction the offence has taken place. Answer is no. It's not mandatory. It can be recorded by any other magistrate of any other court and things like that. Now, while recording confession under section 164, the most important point is that whether the person who is making the confession, whether he is making voluntarily or not, that must be ascertained, and the magistrate must satisfy himself before recording the confession that a person who has come to make confession under section 164, he is making that confession voluntarily. So in this way, you must answer in the interview that when it comes to recording confession under section 164, it can be done by any magistrate and not only by that magistrate within whose jurisdiction the offence has taken place. This you must keep in mind while answering the question. Now, next question. Can Supreme Court transfer criminal case? Answer is yes. Supreme Court can transfer criminal case from one state to another state. This power to transfer the criminal cases from one state to another state has been given to Supreme Court under section 406 of Criminal Procedure Code, and henceforth powers have been given to High Court, powers have been given to Session Court and things like that. But when you talk of Session Court, case can be transferred within the Session Division only. It cannot be transferred from one Session Division to another Session Division. High Court can transfer the case from one district to another district. But as far as Supreme Court is concerned, it can transfer the case from one state to that of another state. Now, this is the only power of the Supreme Court. Now, next question. Now, at what stage can a court alter a charge? Very, very important question. So if you read 211, it is fixed of contents of charge. 212, time, place, etc. and things like that. If you study 215, error in charge. And if you study 216, it is fixed of alteration of charge. Keep one thing in mind. Before judgment is pronounced, charges can be altered. But once judgment has been pronounced, charges cannot be altered. So if you get a question, can charge be altered? Answer is yes. At what stage? Before judgment is pronounced. Now, once charge is altered, now you have to see that no party is prejudiced, and once charges are altered, many things should follow, like re-examination of witnesses and things like that. So that is procedural aspect. But if you get a question in interview whether charge can be altered or not, you should say yes, charge can be altered as per section 216 of CRPC, Criminal Procedure Code, and it must be altered before judgment is pronounced. This is very important. Now, on what ground can a court of session discharge an accused? Now, this is very important question. You must have seen that in 225, public prosecutor to conduct the case, 226, public prosecutor to open the case, and 227, session court can discharge an accused. Now, session court can discharge an accused if it finds that after perusal of the record, it finds that there is no prima facie case, there is no strong evidence. So, if it feels that it doesn't have enough material to proceed against the accused, it can discharge the accused as per section 227 of Criminal Procedure Code. So, our question is whether accused can be discharged. Answer is yes. And when the discharge takes place, it takes place before the charges are framed. Sometimes Sometimes you get this question, what is the difference between discharge and acquittal? Discharge takes place before charges are framed and acquittal takes place after charges are framed. So this is the basic difference between discharge and acquittal. So if you get a question, can an accused be discharged by session court? Answer is yes. An accused can be discharged by session court under section 227 of Criminal Procedure Code. Now, next question. What should be done in a case where the accused is present but the evidence given a language is not understood by him? So sometimes, say a person is from South India and he commits crime in North India, or the person is from North India and he commits crime in South India. Now suppose evidence is being given against him, is being adduced against him in the court of law. Now whatever evidence is being adduced against him in the court of law, that person, that accused, he is unable to understand the language in which that evidence is being adduced. Now what is the provision in that case? The basic provision is that there should be an interpreter in the court of law, and that interpreter must interpret to the accused the language which he understands, and whatever evidence is being tendered, that must be explained thoroughly to that person. And in that case, if this is not done, then accused stands prejudiced and entire trial is vitiated. So if the accused is not understanding the language in which the proceeding is going on, there must be an interpreter to explain to him the language in which he can understand the proceeding. This is must, and it must be done, otherwise the entire trial will be vitiated. Now, next question. The court, an accused before court of session has no means to engage a pleader. What must session judge do in such case? Now, it is a mandate of the Constitution that everybody should be represented by a lawyer of his own choice. If you read Article 22 of the Constitution of India, one of the rights which has been granted to the arrested person is that he must be given a right to consult an advocate of his own choice. Among his many rights, this is one of the rights which has been given to an accused person under Article 22 of the Constitution of India. So if a person is very poor, he is unable to engage a lawyer, then under Article 39A of the Constitution of India, legal aid must be provided to the concerned accused person. So if a person is a poor litigant, unable to bear expenses of the court and things like that, in that case he must be provided with a pleader at the expense of the state, and in that case that pleader must defend him in the trial so that the trial may remain fair and all. Because one person is being represented by a lawyer, another person is not being represented. So in that case, whatever points he wants to put forth, whatever defense he wants to take, he won't be able to take, and in that case, the entire trial will be vitiated. So if a person is very poor, and if he applies to the court that I am very poor, I cannot engage a lawyer, in that case, he must be provided lawyer at the expense of the state. That is a mandate of the Indian Constitution. Now, whether a session judge can transfer a case out of his jurisdiction, if not, then who can? So, as I told you, a session judge cannot transfer the case outside session division. At max, he can transfer the case within the session division. If you want a case to be transferred from one session division to another session division, it must be done by the concerned state high court. It cannot be done by session division. Session division can transfer the case within the session division. He cannot transfer the case from one session division to that of another session division. And this brings us to the power of the court to transfer case from one district to another district and from one state to another state. Section 406 onwards answers all these questions. So if you get a question whether a session judge can transfer a case from one court, from one district to that of another district, answer is no. So who can do that? This can be done very well by concerned state high court. Now this is another very important question. Now what do you mean by cognizable offence? So cognizable offence is an offence in which police can arrest a person without warrant. What is complaint? Now we lodge FIR in the police station and we lodge complaint with the magistrate. Complaint is an allegation which is made orally or in writing to a magistrate with a view of his taking action under the code against some person who can be either known or unknown. So complaint can be oral also, it can be written also. It is always made to the magistrate, and what is the aim? So that magistrate can take action upon that complaint which has been submitted to the magistrate. And this can be against known person also, and this can be against unknown person also. Section 2D of Criminal Procedure Code defines what is known as complaint. And this complaint, when a police officer is investigating a cognizable offence, and later on he finds that the offence turns out to be non-cognizable, in that case the report which is submitted by the police in the court, that report is called complaint, and the police officer will be deemed to be a complainant. So this is all about complaint. Now, under section 433 Criminal Procedure Code, who can do commutation in a sentence? Now 432 you have suspension of sentence, 433 you have commutation of sentence. Now very recently Supreme Court has ruled that only the appropriate government can take this action. So when it comes to commutation of sentence, this can be done only by the appropriate government. Appropriate government can be central government or it can be a state government. Does court have power to give order to the government to commute a sentence? Answer is no. Maximum it can give direction, but it doesn't have power to give order to the government to commute the sentence. Court has held this would be usurping jurisdiction of executive, and that won't be very fair on the part of judiciary. So when you talk of commutation of sentence, this can be done only by the appropriate government. So in this way, please pick up questions of this nature and prepare very seriously for judicial exam interview. Now these technical questions must be there in your mind, and whenever these questions are asked, you must answer them thoroughly with great confidence. And these simple questions are the only questions which are repeated in most of the judicial interview exam. So you must pick up questions of this nature henceforth and practice as many questions as possible. Now before you actually appear for interview, these things should be thorough and your concepts must be very clear. Thank you so much.